Cool. Hi, everyone. Yeah, I'm Vidima, and as I mentioned earlier, I work in employment services. So we are the regulator for the Employment Relations and Standards System. That's our official line. But we're here to really uphold employment standards in New Zealand and to support people to get employment right. We also, sorry, I'm just trying to organize my screen. We also, we hold people to account when there's been breaches of minimum employment standards. So my team's also been tasked with operationalizing the Screen Industry Workers Act. And I've been working across a number of teams to make that happen and provide these services to you. I will pass over to my colleagues, and Bryce, you're up first. So over to you to talk a little bit about your area.
Tēnā koutou katoa, ko Bryce Fleury aho. My name is Bryce Fleury. I'm a bargaining support practitioner. So I work in a team that assists parties in bargaining, including in the Screen Industry Act. So we provide support prior to bargaining, during bargaining, and also when if parties come to get stuck and need some assistance getting through things. So that's where we fit in.
Sorry, Yogita, over to you.
I'm the team leader for the company's office. We look after the compliance team. So my team we are involved in registering the screen industry organizations' registrations in looking after the annual returns. I've got my colleague, my team member, Olivia Tain, who will talk about the process around how to register your industries and when you're required to file and how it follows up from there. Olivia, to you.
Olivia, are you on mute?
Sorry, everyone. My name is Olivia Tan, and I am a technical services advisor, as Yogita has mentioned, and we are responsible for handling screen industry worker organization registration and maintenance. Thank you.
Great, thank you. Andrew, if you'd like to introduce yourself.
Tēnā koutou katoa, ko Anaru Doss Topingoa. Sorry, we're just having some problems with our technology here. I'm the Chief of the Employment Relations Authority. I'm here with Nick Bogue, who's one of our senior authority officers, and we're here to talk today about the role of the Employment Relations Authority in relation to the Screen Industry Workers legislation.
Great, thanks very much. Moving on. So hopefully everyone can see my screen. So a little overview of the webinar today. I will be going through the origins of the Screen Industry Workers Act and how we got to this point, and some of the key parts of the Act as well. Yogita and Olivia will discuss engaging with the company's office. I'll then pass over to Andrew to share how the ERA works under CEWA, and Bryce will talk through the bargaining process and the support that his team can offer. It is back to me to discuss the Employment New Zealand website, and we'll finish off with question time. So a pretty simple agenda there. If we get straight into it, origins. So how do we get here? Many of you will remember in 2010, the Employment Relations Act was amended to remove screen production workers as employees. So their employment status was solely determined by what was written in their contract. If your contract didn't say you were an employee, then you didn't have the same rights as an employee. In 2017, the Film Industry Working Group was formed, and they were established to restore collective bargaining. And they developed a model in 2018 for this, and that was accepted by the government at the time in 2019. The Screen Industry Bill then worked its way through Parliament, was passed successfully last year in December, and came into force. So a little bit about terminology. I know this is really boring, but it's quite important to go through it because we'll be using some of these terms, most of these terms throughout this webinar. So a screen production worker is a contractor. An engager is an employer, a producer, or a production company. Work organizations in the Act is what you might commonly know as guilds or unions. An engager organization is an employer organization. Collective contract is a collective agreement, and enterprise a production or production company. I'll also use CWA quite a lot. So Screen Industry Workers Act, we call it CWA because it's a cool little term there. And you'll hear most of these terms throughout this webinar. So now you've got a slide to refer back to if you ever need it. So over to the overview of the Act. So there's 4 key elements to this Act. Is the changing employment status of screen production workers. There's new rules that have been introduced for individual contracts, which we'll go through the list of that a bit later. CWA also allows access to disputes resolution. So Bryce and Andrew will talk through those, and the development of a process to undertake collective bargaining. Who is covered? We've had quite a few questions coming in about this. People wanting to know if CWA applies to them or not. Unfortunately, we aren't able to give definitive advice in every case about this, but we can direct you to the right information. So our website has quite a lot of detail about that, and the Act itself does as well. There's detailed lists and definitions. So either one of those two, they're the best places to go. But at a very, very basic level, it is what it says on the screen: contractors who do certain types of work on certain types of productions. If you have a contract and it says you're an employee, or you do auxiliary work like accounting or HR, it doesn't apply to you. It will take a bit too long to go through the list, so best to check out the links on the slide. You'll notice most slides do have links for you, and we'll provide the slide pack to you at the end of the, or after this webinar. But yeah, best to check out the links. Go to our website on Employment New Zealand, or the Act itself. But if you want to know for certain, we do recommend legal advice is the best place to go. If a worker or a production is not covered by the Act, then standard employment law or contract law will apply, whichever one is relevant. So new rules for individual contracts. So these are the new rules. Duty of good faith, contracts must be in writing. There's a new process for varying or making of varying contracts. And contracts need to contain mandatory terms. So there's 4 new mandatory terms that all contracts require. Firstly, it's workers and engagers will comply with the Health and Safety in the Workplace Act. There needs to be a term stating how to raise a bullying, discrimination, or harassment complaint and how the engager will respond. There also has to be a term which states how disputes are dealt with and a process for terminations. Contracts also need to comply with any collective contract that exists, and retaliatory termination is not allowed. Again, there's a link there where all of those are listed out in detail on our website. Dispute resolution. So the Act allows for dispute resolution services to be accessed. We've got mediation through the disputes resolution team. It's Bryce. If that doesn't resolve the issue, a determination can be made by the ERA. Andrew will talk through that later as well. The determination from the ERA can be challenged. So if either party are unhappy with the outcome, they can go to the employment court. During bargaining, there's also a couple more options which are unique to bargaining. Firstly, there is facilitation of collective bargaining, where a member of the Employment Relations Authority facilitates between 2 parties. And if they're unable to come to an agreement, parties can apply to have the terms fixed by the authority. Basically, the authority decides the terms to go forward with. So there's 2 levels of collective bargaining. Firstly, there's occupational bargaining, which follows quite a formal process and needs to be initiated through the ERA, Employment Relations Authority, and it covers all of the work done by an occupation. The next level is enterprise, which can be undertaken without the authority's involvement at all and covers specific work within a production or a company. To understand the hierarchy, this pyramid is quite useful. So occupational contracts make up the base. They cover the whole occupation, and enterprise contracts cover a smaller group. And individual, as the name suggests, is on an individual basis. The key to know here is as you move up the pyramid, contracts can be the same or have better terms, but they can't have worse terms. So that's kind of how the three fit under the Act. Occupational bargaining. So this is the big one. There are 7 occupational groups that are listed in the boxes on the right there. The 2 at the bottom are kind of catch-all groups, which are designed to support those people who don't naturally fit into one of the other 5. I won't go into detail of this slide. You can check it out later, and there's a lot of info on our website. But I think what will be quite useful is going through the occupational bargaining process. So this is the very basic list, and the stuff in blue, the lines in blue, are the actions for parties. There can only ever be one occupational contract at one time, and it again applies to everyone in the occupation. So if you go through the list, after the worker and engager organizations are registered, they need to apply to the ERA to initiate bargaining. The ERA, they have a form and a process for this to happen, so it's all stepped out there for you on their website. Once it's received by the ERA, by a member of the ERA, they will assess the application and decide if bargaining can be initiated. If it is approved, parties can begin bargaining, and at number 5 there, parties will discuss, confirm terms, and draft up the contract. Step 5 is also where the dispute resolution services can be accessed to prevent a standstill. So once parties have drafted up the contract, it needs to be submitted to the ERA for a member to assess it, in particular to ensure that there's no forbidden terms in the draft contract. And if it isn't approved, it'll be sent back with notes to let parties know what amendments need to be made before it can be approved. Yes, then if it is approved, parties will then get their members to ratify the contract, and the ratified contract is submitted to MB. After step number 6 there, the Employment Relations Authority's the Employment Relation Authority's role is complete. So they don't have any more involvement after that. But once the contract is ratified, it's sent to MB, and then we take it from there and we submit it to be published. So it's sent to the Gazette and then also published on the Employment New Zealand website, which is a website we manage, and the contract commences on the date noted in the contract. Enterprise bargaining. So again, I'll do the same here. You can check out those later. But enterprise bargaining is much less formal process. So it's only the worker side that needs to be registered to initiate bargaining, and everything is kind of undertaken by the 2 parties. So they bargain, draft, and ratify the contract, and all they do is submit the ratified contract to MB for data collection only. We won't be publishing it anywhere. There can be multiple enterprise bargaining contracts, and they only apply to the workers and engagers within a certain company or production. So yeah, that's it for the overview. I will pass it over to Yogita and Olivia to talk through engaging with the company's office. Over to you guys. Just let me know when you want me to switch through the slides.
Yes, okay, thank you very much, Butima. So as mentioned previously, the first step is registering as a screen industry organization before collective bargaining. So I will present to you how the documents and where you can submit your application as a screen industry organization. So under the Screen Industry Organization Act, there is a Registrar of Screen Industry Organization, and that person is authorized to maintain a list of worker and engager organizations on an internet site, review applications to register as a screen industry organizations. And after reviewing and seeing that all requirements are met, we must register the organization as a screen industry organization and provide a certificate of registration. And that certificate of registration is also publicly viewable and is a conclusive evidence that that organization is registered as a screen industry organization. Next slide, please. So if you will have a copy, I think, of the presentation, and if you click on this link, it will take you directly to the Screen Industry Organization website. So this is just a screen capture of the welcome page. So it gives you the links how to register a Screen Industry Organization, searching for a Screen Industry Organization, a list of the registered organizations. Actually, we have 2 that are registered at the moment, and further information about the register and the Screen Industry Workers Act. Next slide, please. So this is like a representation or a flow of the registration process. So the first step towards registration is registering as an incorporated society. And worker organizations can also be registered as a registered union. So after registration as an incorporated society, they can register as a union and then a Screen Industry Organization. And then after we review it, we will include them in the registration, in the register, and provide a certificate of registration. For engager organizations, they are still required to be an incorporated society before applying as a Screen Industry Organization. And then we will review their application, and if everything is correct, then we will approve the registration and provide a certificate of registration. Next slide, please. So who is eligible to register? So the entity must be a registered incorporated society. A worker organization may be registered as a registered union under the Employment Relations Act 2000. The organization must at least have 15 members, and it must have rules that comply with the provisions of the Incorporated Societies Act, the Employment Relations Act if they are a registered union, and the Screen Industry Workers Act. So the last bit is that you cannot apply to be an engager and a worker organization at the same time. So it just means that both you are working independently or at arm's length with. So for example, if you're a worker organization, your organization is running independent of or at arm's length with an engager organization, and vice versa. Next slide, please. So what documents do the organization needs to submit? So there is a form SIO1, which is registering as a Screen Industry Organization. That link provides a link that will take you directly to a copy of the PDF form. And the second, accompanying that form is a copy of the Incorporated Society Certificate of Incorporation under the Incorporated Societies Act 1908. If you're a registered union, then you will also need to provide a union certificate of registration under the Employment Relations Act, and a copy of the Incorporated Societies rules under the Incorporated Societies Act 1908. There is also no fee to register as an SIO. Next slide, please. So where to send your application? The best, quickest way is to send to us by email at compliance@companies.govt.nz, or you can send it by post to the Registrar of Screen Industry Organization, Private Bag 92061, Victoria Street West, Auckland. Or you can courier it to our physical office at Level 1, 162 Victoria Street West, Auckland. Next slide, please. So here are other useful links and information that would help you with the process of registering as a Screen Industry Organization. So the links provided are starting an incorporated society, registration fee applies. If you are already an incorporated society, but your society was dissolved in error, you can apply to have it restored to the register, but a restoration fee applies. There is also some law changes. Well, not some law changes. There is going to be an overhaul of the Incorporated Societies Act that will happen in October 2023. So it will happen later this year, and my colleague Yogita will explain further what it entails. And then the last link is the link for registering unions. Next slide, please. I think Yogita, this is yours.
Yeah. Hi, everyone. It's Yogita here. So along with the skin industry registration, my team also looks after the Incorporated Societies Act, everything to do with the registration and the reminders and the filing of the financial statements. So as Olivia said, so if your entity is a registered incorporated society now, in April, when the new, in October, when the new legislation goes into effect, the Incorporated Societies Act 2022, all existing incorporated societies will have to re-register under the new act. However, the lead time is until April 2026. So you can start transferring yourselves into the new regime from October, but it ends in April 2026. So if you have an incorporated society now under the 1908 Act, you can still register as a SIFO. However, after October, at some point, you will have to re-register your incorporated society under the new Act. If you register an incorporated society after the 5th of October 2023, you will automatically be registered under the new Act, and you will not need to re-register. And then at the same time, you can register your screen industry organization registration at the same time. Next slide, please. So as we said, the re-registration period for existing incorporated society will be from the 5th of October 23 until 5th of April 2026. So again, societies that have yet to register during the registration period will be under the provisions of 1908. So if you were to say, for example, an existing incorporated society and you register under the new Act and the screen industry, we will still keep you under the 1908 until that incorporated society re-registers themselves. The incorporated society cease to exist when a society fails to register during this period. So after the 5th of April 2026, if you are not re-registered under the new Act, that's it. You will not, the incorporated society will cease to exist. And they cannot longer be sued or sign contracts. The entity may continue to operate as an unincorporated body, and the debts must be paid in assets distributed according to the jurisdictional society of or under the registrar's decision. Next slide, please.
Yes, so that's my turn, sorry. So after registration, a skin industry organization has some annual compliance requirements that they need to file. So all screen industry organizations are incorporated society and must file annual financial statements under the Incorporated Societies Act 1908, or after October, it will be under the Incorporated Societies Act 2022. There's no fee to file annual financial statements, and this is a very important thing. We do get a lot of queries about this, but even though a society does not have any income or expenditure, you must still file annual financial statements. So we call it a nil financial statement. So it will what will happen is if you break down the expenses and the income for the year, the income will be 0 and the expenses will be 0. So even though you have nil income or expenditure for that year, you will still need to file annual financial statements. If the organization is a union, it must also file an annual return of members. I'm not sure if any one of you is a member of a union. So every year, your union must file an annual return of members, and it is broken down by gender and by industry. There's also no fee to file the union annual return. And then finally, all registered screen industry organization must file their own annual return of members. I think the difference between the union annual return and the screen industry organization is, for the union, it's just broken by gender and industry. And for screen industry organizations, it's just broken by, I think, the industry. Next slide, please. So if you are a worker organization that is a union, you may already be submitting membership information to the registrar. You may permit the registrar of screen industry organizations to obtain the membership information from the registrar of unions. So this means you only need to file one membership return with the company's office, but this only relates to the number of members that you have. We also need further information from the union and the screen industry organization, because for the union, we need the information broken down by gender and industry. And for screen industry organization, we need the members broken down by industry. Next slide, please. So if you decide not to be a screen industry organization, cancellation of your registration can be filed by sending a completed SIO3 form. You can send the form on the addresses that we have provided for registering a SIO, screen industry organization. Another way to cancel a screen industry organization registration is when the Employment Relations Authority, or the ERA, directs the registrar to cancel the registration. Next slide, please.
Right.
Great, thanks very much, Yogita and Olivia. Sorry, Andrew, over to you.
Thanks very much, Boomer. Nick's going to start, and then I'm going to carry on. Then Nick's going to come back around. So, okay, it's a game of 3 parts here.
All right. So, the authority website has a web page with information on the screen industry. That all of application forms are there. Next slide. So the forms outline the requirements to apply. The applicant organisation needs to be registered as a screen industry organisation, and they'll need to supply the certificate of registration and a copy of the bargaining notice. They must have a simple majority of their membership within coverage that support the initiation of bargaining. So, yeah, anything over 50%, I believe. They should also need to set out how they intend to conduct the ratification vote, especially how they're going to allow people that are within coverage but aren't a member of their organisation to participate in the vote. And only worker organisations can apply to initiate bargaining for the first contract for the occupational group. Next slide.
So once an application has been made, a member of the authority, of which there are currently 25, will assess the application and will also call for public submissions. So the public submissions call will be on our own website. There'll be a banner initially at the top of our website, also on the Employment New Zealand website, and we tend to use LinkedIn as well. So we may use our LinkedIn profile to also call for public submissions. Ordinarily, the submission period is 28 days, but this may be extended and is likely to be extended by a member, particularly in the first tranches of bargaining. So the first round of bargaining, I suspect there'll be more sort of liberalism taken in terms of timeframes. So obviously the member assesses whether there's enough support for bargaining based on the submissions made, and also on an assessment under Section 39 as to whether a majority actually exists. So if a member decides that bargaining can be initiated, this is can happen formally within 28 days, but also happens automatically after 28 days. So essentially, if something happens and the bargaining is not initiated within 28 days, it happens automatically after 28 days, which means that the process doesn't have to start anew. Next slide, please. So there's various, this is sort of a technical process where the authority has the ability to add or remove parties. And we have forms available on our website. Nick's referred you to the drop-down menu on our website, which deals with, which contains the forms. A member will make the final decision about this. The conditions in which parties may be added or removed are set out in the legislation. So sections 44 to 46 of the legislation I'll refer you to. And also, logically, bargaining will stop if there's no longer at least one bargaining party, each representing workers and engagers. Next slide, please. So dispute resolution through the authority. This is in the event that bargaining doesn't go according to plan and there's no judgment made about that. These things happen. Obviously, facilitation, which is a current process that we engage in. And so there's a form on our website which will deal with generally a dispute under the C one, which Nick will come to in a moment, which is how you'd seek facilitation. The process of facilitation is effectively where a member of the authority just takes control of the bargaining, effectively chairs it and facilitates it through the dysfunction and tries to reach agreement at the other side. So we have a lot of experience in relation to this. We've just been involved in the Auckland bus drivers dispute and the PBTA dispute. We were involved in the pulp and paper dispute last year. We've been involved in various iterations of health disputes, nursing, senior doctors, junior doctors. So it is something that the authority is very, very familiar with and has been over the last few years very successful with. So we had 11 facilitations last year. We've currently had 6 applications and we have 3 facilitations on the go currently. Final offer arbitration is the process by which the authority will determine the outcome of a collective contract in the event that agreement can't be reached through facilitation or some other means. And the decision made is final and cannot be challenged and is ultimately binding on the parties. And that process will be done by a panel of 3. So it will be chaired by a member of the authority and one representative of the engagers and one representative of the union. The unions will participate and make the decision accordingly. Any decision of the authority on a matter is called a determination. And as is the case under the Employment Relations Act, decisions are legally binding and are published on our website. So if you look around our website, you'll find the determinations database, which contains something like 19,000, 18,000 determinations, which have been published over the last 23 years, and determinations in relation to CEWA will also be there. Generally, there's a right of challenge to the employment court in most circumstances if you're unhappy with the determination of the authority, and that has to be done within 28 days. Next slide, please. So in terms of assessment of a contract, once it's been negotiated, drafted, and is ready, it's sent to us. So we'll provide a basis which that's done. There's no form required. It'll just simply be a case of sending it to us and probably via email. We may be able to have it uploaded to Resolve, which is our electronic filing system. Or there's actually going to be a website and email address as well, as it says there. We'll check the terms that have to be included, so the mandatory terms, and ensure that you've negotiated no prohibited terms, although I'm sure that won't be the case. If any issues exist, we'll be communicating with the parties and we can amend the contract and resubmit it. And once the draft contract is approved, then the process of ratification starts. So we intend just to simply we intend just to draft a brief determination setting out the fact that the contract is approved, and then it'll of course go to ratification, which is the ultimate binding process. Next slide, please.
So anyone that's covered by the Screen Industry Workers Act can apply to the authority to resolve a dispute. I think it's Form 22. memory. If disputes can't be resolved through negotiation or mediation, then the authority determine that in the usual way. The Act says that the authority must determine the dispute as if it were determining a dispute under the Employment Relations Act. So same process as for other employment relation problems. Yeah, next. Thank you. Thanks.
Oh, that's it. Thanks very much, Andrew and Nick. Bryce, over to you. Talk through bargaining support.
Great, thanks, Padima. And I noticed there was a question in the chat about whether these slides would be made available to people afterwards. I believe the answer to that is yes. Is that right?
Yeah.
Yeah. So look, what I'm going to talk about is we've had discussions here about the sort of the technical aspects of the legislation and the sort of the black and white of it. If you like, I'm going to talk about the grey area about bargaining itself, and talk about these four issues: good faith, the bargaining team, the process of negotiations, and a bargaining process agreement. The first thing I just do want to point out to everybody that this is a new piece of legislation, and we're all finding our way through it, including the MBIE and the authority, as well as the parties. So, and I know that in this industry there hasn't been a recent history of collective bargaining. So I think it is fair to say that everybody will be finding their way as they work through this process. And so what I want to talk about really is what will give you, I believe, the best chance of success in terms of your collective bargaining, but that doesn't always guarantee that will happen. And there are, as Andrew's already talked about, some mechanisms to deal with when parties get stuck. But first of all, the next slide, thanks, Padima. What I just want to talk about is the concept of good faith in this legislation, which is similar to that in the Employment Relations Act. And so when it comes to bargaining, not only is there the general requirement of not misleading or deceiving in terms of behaviour towards each party, but there's also a number of additional requirements. So what the Act says is when, at a minimum, that the parties should at least meet together, should listen and consider each other's proposals. They should communicate and respond to each other. They should continue to bargain even if they do get stuck on a particular issue. So that if they are stuck on one thing, that doesn't preclude them from moving on and talking about other issues in the bargaining. They should respond to reasonable requests for information, and also recognise the authority of the other side. So not do anything that undermines the authority of the other bargaining party, and ultimately not to undermine the process. So if you like, there is a few don'ts, but a number of positive things that parties can do to ensure they meet their good faith requirements and to assist the bargaining. And effectively that is to approach the bargaining in good faith, to listen to the other side, to respond to them, and to be open. Next slide, thanks, Padima. One thing though, good faith doesn't mean is that parties have to agree with each other. And sometimes we get this in collective bargaining that one side or the other gets frustrated that the other side won't agree with them and argues that that's a breach of good faith. Good faith doesn't mean that you have to agree. What it does mean is you have to listen to the other side, consider their proposals and respond to them, but it doesn't mean that you have to agree with them. It also doesn't mean that you have to limit to what you bargain over in terms of what one party wants. Both parties can decide the terms in which they want to be to negotiate over. The other thing I want to also say about what good faith doesn't mean is that it doesn't mean that parties have to be reasonable or unemotional when they're bargaining. Bargaining can be a tense process. It can be emotional, and the fact that people occasionally those emotions can rise to the surface, and in and of itself isn't a breach of good faith. So people just need to be prepared for that bargaining can be a tense process at times. Obviously, the aim is to try to limit that, so that parties can focus on getting things done. But the fact that things do get tense or emotional in and of itself isn't a breach of good faith. Next slide, thanks, Padima. So look, when you are considering who you want to be at the bargaining table to represent your interests, the things we think that would be useful to consider in the makeup of your bargaining team is to ensure that you have people that have knowledge of the industry or occupation that's been negotiated over, that are credible amongst the people they're there to represent. So they have knowledge, they have credibility, that they have authority to make decisions. This is a very important aspect, that at the table, small or micro decisions will be made all the time about how to respond to things across the table, and the people that are representing you need to have that authority to be able to make that response, and also an agreed process within their bargaining side about how they're going to do that and who's going to do that. It's important that people understand their roles in the bargaining team. So you generally will have someone that's a lead advocate or spokesperson. Then other people will have different roles. So there may be people there that have particular expertise in a particular occupational subject area. You also need people that might be responsible for taking a record or notes of what's being discussed at the bargaining table, and people that might be responsible for communicating to their constituents during the process of the bargaining. So it's just really useful to be clear about who's doing what on the bargaining team. I think a really important thing that sometimes doesn't get the recognition that it needs is about resourcing your people that are on representing you in a bargaining team. Bargaining can be a drawn out affair. It can take months and sometimes years. And so people that are going to be on the bargaining time need to be resourced to be able to participate in that. They need to be given the training to understand their roles, and just simply the time to be involved. So it can be a resource intensive process, and bargaining teams need to be resourced accordingly. Next slide, thanks, Padima. When parties come to the bargaining table, particularly in this industry where probably people are familiar with each other, but not in terms of collective bargaining, it's important just to get to know who the people are in the room, to know each other. Look, I think it's really important to keep in mind that everybody on a bargaining side is there to do a job. They're there to do hopefully a good job to get the agreements finalised, and it's important to recognise that everybody there is there to play a role. So it's important to treat people with respect and to respect that role that they play. I think it's important to be as open as you can be in a bargaining context, and there are processes that can assist in doing that, using an interest-based approach. And I think it's important to use the bargaining should maintain trust between the parties rather than destroy it. So it's important to focus on the issues rather than the individuals, look to the future rather than necessarily the past of what's happened to get here, that now parties are at the table and there to do a job, and to focus on achieving that. And as I mentioned, there are processes that can be used in an interest-based way that focus on what are the interests that we're trying to deal with, what are options that we could look at rather than single solutions, and how we could evaluate those options against agreed criteria. So trying to take if you like, the depersonalize it and to have a more balanced approach to how to assess options rather than single solutions. So these are all techniques. There's very many different ways that people approach bargaining. There's no one way that is the magic answer to collective bargaining. If there was, then we'd all be using it. But there are steps that you can take as a member of a bargaining team to at least give yourselves the best chance of achieving an outcome. Next slide, thanks, Badima. One of those things that can assist parties is developing a bargaining process agreement, which simply sets out how the parties, the expectations of each other and how they're going to operate. So this is a very useful document so that everybody understands and is clear about how at least the basics of the process will work. So in that bargaining process agreement, you can include things like who will actually be the representatives, who will be attending the bargaining, the size and makeup of each bargaining team, how often the bargaining team will bargaining sides will meet, simple logistical issues like where will they meet, when, and who will meet the costs of that, what communications there will be during the bargaining and how those will be managed. So for example, that could be that there is a agreed statement coming from the joint statement coming from the bargaining teams, or at least that for separate statements that those are run past each other before they've communicated externally, are just some good things to consider. How information will be provided if requested, and what the associated costs of that would be, and finally how, if you do come to a disagreement, how you will manage that. So for example, you could have in your bargaining process agreement that if standstill is reached, that you might use the services of the mediation service to assist you, or a third party if you do get stuck. So that's the bargaining process agreement, which, as I say, is very helpful in setting out how the bargaining will work and the very sort of basics of that. Next slide, thanks, Badima. So as we mentioned earlier on, there is assistance that can be provided through the dispute resolution services team at MBIE, which I'm part of, and basically we can provide support to parties who are setting themselves up. So in terms of forming a bargaining side, we can also provide assistance through facilitating the bargaining itself, either as one-off occasions or going through that. And as I've mentioned, if the disputes or if parties become stuck, there's the ability to use the free mediation service of MBIE to help parties to get through that. So basically, there's assistance at the beginning, middle, and end of the process. That assistance is voluntary. Parties don't have to avail themselves of those services, but obviously we recommend that you do. And the reason being, I think, is it's often useful to have a third party neutral involved when things get sticky, just to have that someone else with a fresh pair of eyes assist the parties to try and work through issues and problems. And as Andrew's mentioned, both the authority and mediation services are well experienced in doing that. That's what they do, and so there's a number of people with expertise that can assist the parties to help them along the way. And the link is there in the slide for how you can find out more about mediation services. Okay, that's me. Thanks, Badima.
Cool. Thanks very much, Bryce, and all the panel members. It was very informative, so thank you very much for your time. Quick little bit from me about the Employment New Zealand website. So most of the information from today can be found on this website. It's a website that MBIE look after, my team looks after, and it's where you can get more detail about anything that was discussed. There's also a dedicated section on the website which you can click through. If you click on the orange circle there, and this is the website. It looks pretty basic, but it has everything you need. So there's a toolbar on the left there, and it takes you through to the key parts, key sections of SEWA. And we will be releasing some more collateral shortly. Actually, this morning I got confirmation that 3 of them are ready. So this will help you understand better parts of SEWA, and it's come from, we heard this from you that you want to help with these things. So the 3 that are ready that I'll actually send out after this webinar with the slides is a 1-page PDF fact sheet, which gives you an overview of the key information about the Act. There's a 2-page fact sheet and a flowchart which talks all about coverage, explains what types of productions and what types of work are covered. There's also a detailed individual contracts guide for engagers, so that outlines new rules and requirements for individual contracts under the Act. We're still in the sign-out phase of a comprehensive occupational bargaining guide for guilds and engagers, so that outlines a process from registering through to commencement, and that should be completed in the next 2 to 3 weeks. So look out for that. But we will email these through to the mailing list and put it on our website. So if you're in this webinar, you will receive a copy. The website will also have status updates for active bargaining activities. So anytime you wanted to see the high-level process of where occupational bargaining activity is at, you can go to the Employment New Zealand website and it'll have a status update there. A majority of the website will be on the Employment Relations Authority website, but there will be tons of links to and from, so you can navigate between the two pages quite easily. So what our websites hold, I had mentioned ERA and ENZ all over the place, so I thought this slide would be quite helpful. The Act itself is very clear on who holds what. So ENZ, the website that my team looks after, is very general, gives high-level info and tells you about CEWA itself. There's also links all over the place to pretty much everywhere, to all the panel members pretty much. So the Companies Office, Mediation Services and the ERA will be held on that website. And the final ratified contracts will be there as well at the end. There is also the CEWA email address is also the one to use if you want funding. So there is access to funding during occupational bargaining. So that's managed through that CEWA inbox. The ERA will hold all of the detail though. So all of the active and past bargaining activities will be held there. And if you want the decision document, you want to make a public submission, or you got a query about a bargaining activity, that ERA website is the place to go. So that's it from us.